In 2010, Transparency International Bangladesh told us that the judiciary was the most corrupt amongst the service sectors of the country. It told us that the corruption in the judiciary in 2010 had doubled since 2007. One simply has to do a search on the web to find the talk of the tarnished image of the judiciary as a result. Mahatma Gandhi once said, if a few drops of the ocean are dirty, the ocean does not become dirty. I say, call me biased if you like, that the same applies for the judiciary. I am not questioning the statistical, scientific data of the TIB. It is not my place to do so. What I am trying to say is, let us not sideline the great work that the judiciary is doing too. A former judge of the Supreme Court, in a very famous case, once said that the judiciary is to play a vital and important role not only in preventing and remedying abuse and misuse of power, but also to eliminate injustice. The two cases that I will discuss now are examples where our courts have done just that, taken positive, proactive, progressive steps to eliminate injustice. First, the fatwa judgment. Now, what is fatwa? Fatwa is a religious ruling, a scholarly opinion on a point of Islamic law. Unfortunately, in our country, the word fatwa has become synonymous with fatwa violence. These so-called rulings in the name of fatwa has been a cause of considerable injustice for poor rural women in our country. The issue of fatwa and fatwa judgment was effectively dealt with in the case of Blast versus Bangladesh. This case was filed against 7 separate incidents of violence against women pronounced by traditional dispute resolution processes. In 4 out of the 7 incidents, the punishments were 101 lashes being inflicted on the women, the victims, in public. The matter eventually moved up to the appellate division, the highest court. The courts, in consultation with 10 legal experts, or amicus curiae, and 5 of the country's most prominent alims, or Islamic scholars, said that a fatwa can only be pronounced by people properly educated in religious matters. And a fatwa cannot be forced on anyone. This ruling is definitely one step forward towards empowering women in our country. Next, a child custody case. Most people in our country think they know the law when it comes to child custody. A boy, a son, stays with the mother till the age of 8, and a girl till puberty. And then the guardianship moves to the father, right? Really? Let's come to Ali and Hassan. The mother filed for dower and maintenance payments. The father filed for custody. In deciding the custody of an 8-year-old boy, the court held that an order in relation to a custody of a child should never be presumed to be inscribed in stone. It should be fluid. Rather, the best interests of the child should be taken into account. The court held and took note that the decision as to which parent shall have custody and which parent shall have how much access to a child is a most delicate decision, and that a wrong decision may create a traumatic situation for the child, which would result in indelible psychological damage throughout his or her life. Hence, the child should be allowed to freely express his views, and the judge adjudicating the matter should take these views into account when deciding the welfare of the child. This decision again brought our laws in line with international conventions, and especially in line with custody provisions of the Convention of the Right of the Child. Now, if my discussion of the two cases have piqued your interest even a little bit, you might be wondering, where can I read these cases? Well, Supreme Court cases are reported in law reports. Law reports in Bangladesh are published and printed in book formats. These books you can buy at the court premises or from specialized law bookshops. But what about the cases that are not reported? Let's talk some numbers. Since 1972 to 2009, approximately 350,000 cases have been disposed of by the High Court. Since 1972 to 2011, approximately 22,000 cases have been reported. Now, case reporting is important because it sets precedent. Basically, how an older case is decided affects how a future case will be decided in a similar set of facts. The number that you see on the slide is what, in my very Bengali way, I call a system loss. This is a very simplistic calculation of the number of cases that have not been reported. There is another question here. How many of these cases can you find online? This is where our work comes in. But let's start from the beginning. So, 2008, I finally received an instruction for a sizable commercial litigation. Us, a newbie law firm against a very well-renowned, very established chambers. The topic? Simple, letters of credit. There must be hundreds of cases on LCs filed every year. Ergo, there must at least be 100 decisions on LCs. My friend and I came up with a brilliant idea. What if we could find a case where our opposition lawyers had argued an LC case from our perspective, our standpoint? Excellent. We were excited. So began the research. Guess how many cases we found? 20 on the topic, and none fitting our exact criteria. That, to me, was ridiculous. There must be cases out there just not reported. The next day, I went to court. Call it the universe conspiring or coincidence, but the judge presiding at a moment emotively started talking about the dwindling standard of legal reporting and the need for new initiatives. This was my light bulb moment, my ta-da moment. We decided we wanted to publish a law report which would measure up to the look, feel, and editing standards of international legal reporting. Now, law reports. Law reports publication in Bangladesh is governed by the Law Reports Act 1875. No, 1875. This is basically a one-page law telling us that we need government permission for a case to be taken as binding authority by the courts. The government decision here equated to the permission of the DC, or district commissioner. Simple? Not quite. The requests for papers were unending, the bottlenecks numerous. After 1.5 years of running after a law report permission, the frustration was palpable. It was a time for decisions. Abandon the project or find an alternative. Act now or forgo. We decided to take a leaf out of Nike and just do it. The idea for our venture, an online forum, was born in December 2011. The more we analyzed the idea, the more exciting it became. With an online platform, we could be limitless, borderless, and we didn't have to stick to cases anymore. Legal articles are not just read by lawyers. Landmark cases are a discussion point for economists, journalists, politicians, academics, those interested in the arts, and concerned citizens alike. Legal news, court news, is a part of our everyday lives. With an online database, we could build a knowledge center, a reliable legal reference site. With our venture, we aim to bring to you information that is public, but that is not easily accessible. Like the cases I mentioned. Our aim is to be not just a one-stop solution for all things law, but also to be the first point of reference when you, the audience, want to read or research anything to do with the law. And we want to do it for free. Free as in unpaid, free as in freely accessible. And this is a glimpse of a little bit of what we have achieved till now. We have created two search engines, the case search engine and the advanced search engine. The case search engine is unique. In other search engines, even internationally, you'll find searches by title, by act, by subject. But searching by judge is absolutely new. In my experience, I have not seen this before. When we went to judges to collect copies of their judgment, we found that a lot of them have not kept copies or have lost their copies. We believe we can help here. If we can collect even some decisions on a piecemeal basis, in a few years, we'll have a substantial database. In the articles section, we publish and link up articles by current practitioners of the law, both seniors and juniors. Here you will find a feel of the topical legal deliberations. In the research papers and publications, we have showcased published papers and excerpts of books from some of the premier legal minds of the country. This is a personal favorite of mine. Looking forward, we are working on a number of editions like infographics, webinars, legal job postings, law firm postings, legal mentoring, discussion forums, and free legal forms. Since launching our site some 7 months ago, we have shared on our platform hundreds of free legal documents. With our initiative, we've found that a good idea evolves on its own, that there are wonderful people out there who are willing to selflessly contribute to a good cause. We want Think Legal, our platform, to be about knowledge, about progress, about change. We want to create a platform of scholars and would-be scholars. Fame does not always equate to being the best. Sometimes the quiet ones are the exceptional ones. Sometimes the kudos is well-deserved. Let us show you the lawyers that we should all be proud of. Go to Think Legal and judge for yourself. You will find courage, analysis, depth of thinking. You will find vision and innovation. And if you find something that you do not agree with, we urge you, we encourage you to write about it, to argue it, to highlight it, to move it forward, to initiate the change, to be the change. Thank you.